Okay, following DHS's response in the DACA litigation yesterday and the videos that I've made, I've gotten a few questions. One, though, has stuck out, which is, are DACA recipients in Texas who are no longer eligible for work authorizations and will now accrue unlawful presence no longer be able to travel on advance parole? In other words, is their accrual of unlawful presence going to prohibit them from seeking advance parole and or traveling or coming back with advance parole? And this is an interesting question. I'm not really sure where it stemmed from, but I'll point this out. There are many, many, many people who have some type of temporary protected status or deferred action who have sought advance parole and have traveled on in advance parole after accruing unlawful presence. In other words, not all DACA recipients obtained DACA prior to turning 18. Many accrued years of unlawful presence prior to getting deferred action, and yet still sought advance parole, got it, and were able to travel with advance parole. Likewise, many TPS applicants and TPS holders accrued unlawful presence prior to TPS being announced. Yet, they got TPS, they later sought advance parole and traveled with advance parole. In both situations, these individuals had accrued unlawful presence prior to both seeking and traveling with advance parole. So I don't know that this is, correlated. In other words, the accrual of unlawful presence is going to prohibit them from seeking travel with advance parole. What I will say is advance parole is a discretionary benefit given out, right, by USCIS in most cases to DACA recipients and not guaranteed. So while it is not on paper something that it has been taken into account in the past, there's nothing saying that it won't be. I guess we won't know if they're going to be issuing advance parole until we try. However, the unlawful presence accrued prior to seeking it or accrued prior to travel on its face shouldn't be prohibitive.